Welcome to The Insurance Lawyer, the podcast where we discuss topics concerning claims and lawsuits between insurance companies and their policyholders. I'm your host, Evan Schwartz, founding partner of Schwartz, Conroy & Hack. The firm represents business and individual insurance policyholders in claims and lawsuits against their insurance companies, helping policyholders get their claims paid. Today, we're doing part 2 of a series with my wonderful guest. His name is Josh Weisberg, and we've already done one of the series earlier on business office insurance, the BOP policy or all risks policy, whatever you like to call it. But Josh is the Senior Counsel and Director of Risk Management Services at SterlingRisk Insurance. And Josh and I have had the privilege of working together over the years and helping his insureds and my insureds get their claims paid. Welcome again, Josh. Really glad to have you.
Absolutely. Thank you, Evan, for having me again. Very much appreciated.
My pleasure. So we started our last episode with the commercial office policies, and today we're going to talk about construction insurance policies. And I think what I'd want to start with is, has the market changed, just as we started with commercial office policies? Has the market changed as a result of COVID in the construction insurance coverage world?
That's a great question. And I think the answer is yes. The market for insurance in the construction sphere is absolutely hardening. Now, some of that can certainly be attributed to kind of the widespread phenomenon of hardening markets related to COVID, but it can also be attributed to a lot of different other factors as well that predated COVID. When we talk about social inflation, we talk about jury verdicts that are being returned in some of the jurisdictions that we constantly think about when it comes to construction accidents, including New York and California and Florida. As juries start to award higher and higher liability verdicts, the exposure to insurance companies has exponentially increased. And unfortunately, a significant amount of that expense, those payments, is now translating into premium increases. There is no doubt that COVID has exacerbated or created certainly additional pressure on the market, but all of those things tied together are absolutely driving premium increases across the board, and particularly in the construction domain.
Okay, so it's getting harder for you to do your job, it sounds like, as a result of COVID. But in terms of the market in and of itself, and I'd like to focus on generally what any construction company doing construction anywhere needs to think about in terms of their exposures and the insurance they need to protect themselves. And then also a separate conversation about how that changes if you're in the 5 boroughs of New York City.
Okay, those are both great points. In terms of what construction companies need to be doing in order to protect themselves, that becomes more important now than it ever has been before. Because as you said correctly, the market is hardening. Insurance policies are becoming more expensive. So the best way to manage that expense and to contain that expense is to make sure you have the right insurance products protecting you, but also that you're maintaining those insurance products in the correct fashion. What does that really mean? It means that you have to first and foremost make sure that your insurance policies have the right terms. And when we talk about that, there are a couple of really hot button issues or items that you have to look at when you're addressing the question of your liability insurance. And liability insurance, it almost stops and it starts for a construction company with their general liability and their excess liability insurance policies. That is the core insurance product that you absolutely must have in order to do business as a construction company. In order to get licensed to do business as a construction company, you need to have that product.
What am I protecting if I've got a general liability policy as a construction company?
So a general liability policy in its simplest sense is going to cover you for claims that third parties, so for example, the owner of the construction project, if you're a general contractor, or the general contractor itself, if you're a subcontractor, third parties that bring claims against you, lawsuits for bodily injury or property damage, are the core parts of your general liability policy. So for example, a classic claim would be somebody slips and falls on the construction project site and sustains an injury. If they then turn around and sue your company for that bodily injury, your general liability insurance policy is where you're going to look for coverage in order to cover the law firm fees, the legal expenses, the attorney's fees, plus whatever amount you have to pay to settle the claim, or if ultimately a verdict were to be rendered against that claim, that's the policy that's going to pay for that.
Okay, so what other types of exposures do you see typically when you're looking at a construction company that you want to make sure is protected by the general liability policy?
So some of the other exposures that you're going to look to cover are going to be what's called third-party property damage. And what that basically means is, as a contractor that's doing work on a building, if you, for example, are a plumber and you're working on a pipe and you damage that pipe, and as a result of that, there's a water burst and the building sustains water damage as a result of that pipe burst, the general liability policy will cover you not for the damage to the actual pipe, but certainly for the ensuing damage, the damage to the rest of the building caused by your alleged negligence. That policy will pick it up. So when we talk about the kinds of claims that we're looking to cover under a general liability policy, we're talking about those bodily injury claims and those property damage claims. And I know that we said that we would talk about this in a little bit, but now is a perfect time to talk about, I would think, what's called labor law exposure. And this is particularly and only applicable to those listeners who are paying attention in the city and the state of New York. The state of New York has a strict liability statute called Labor Law 240. And Labor Law 240, in essence, states that a construction worker who is injured on a project site has the right to assert a claim for, in essence, strict liability emanating from that accident, subject to certain conditions being met. The accident has to meet those conditions, such as a gravity-related injury is one example. If that's involved, then the strict liability statutes of the labor law potentially apply. This is a core exposure for those contractors operating in the city of New York or even the state of New York, and they must be protected against that, because you cannot argue in a Labor Law 240 claim that the worker caused his own injuries. For the most part, the liability is absolute, and the only question in those cases is how much money the construction worker is going to be entitled to for those injuries. There are obviously claims of significant value.
Right, so they call that in the legal industry strict liability, and I think it's appropriate for me to point out, as we have this discussion, that Josh, prior to joining Sterling, was practicing law and is a lawyer admitted to practice in the state of New York. But they call those strict liability claims. Liability, regardless of whether or not the injured person was at fault. So in a lot of those cases, a person gets hurt on the job, they bring a lawsuit, and they get summary judgment of liability against whoever they've sued who was involved in the chain of employment and supervision on the job. And then the only question is, what's the injury worth? And so those liability exposures are significant. And a lot of those injuries also, because it protects laborers, particularly from all types of height-related work and all kinds of other types of dangerous work that happen on a construction site. So the injuries on those cases are often far larger than your standard slip and fall or automobile accident.
That's exactly right. It's not out of the norm. And in fact, I would say that it's probably the rule and not the exception. In a labor law related claim, you have to think that you're dealing with a 7-figure injury, meaning you have to think your exposure is potentially in the millions of dollars when it comes to a labor law claim. So it's a very significant exposure. And it's also when you tie that back into the insurance product itself, the insurance policy itself, this is one of the critical issues that you must look at in your general liability insurance. Again, that bodily injury insurance policy, you have to make sure that those kinds of claims as a construction company are covered under your policy. And because they're worth so much money, there are many insurance companies out there that will look to exclude or to bar coverage for those kinds of claims, for those strict liability claims, because they're worth so much. And the way that that's kind of, the general catch-all phrase that you may hear from your broker or from your insurance advisor or your consultant, or even from your insurance lawyer, that we use to talk about those kinds of provisions in an insurance policy is called action over. Action over exclusions or action over limitations. And all that really means, distilling it down to kind of its brass tacks, is the policy contains an exclusion that says we are not going to cover claims for injuries to your workers. We are not going to cover claims for injuries to someone as the result, as Evan, you correctly pointed out, as a result of falling from a height. There are many different ways that insurance companies try to exclude those claims from your insurance products. and you must be on the lookout to make sure that your policies do not have those kinds of exclusions inside them. So talk to your insurance consultants, your insurance brokers, and your insurance lawyers to make sure your policies are set up the right way.
Yeah, and I can tell you as a lawyer that gets involved in these cases, there are so many instances where I consult with and or potentially represent a client who got insurance coverage as a general contractor, but didn't make sure that they had the proper, as Josh used the phrase, action over coverage from their subcontractor to make sure if they got named in the lawsuit, or if the owner gets named in the lawsuit, the owner of the property who contracts with you, the general contractor, and they have an indemnification provision in their contract that says, hey, if anybody gets hurt on your job, that's not my problem. That's your problem, and you got to indemnify me. The general contractor realizes that they didn't make sure that there was action over coverage in place to protect them from the claims that inevitably arise on construction sites.
Definitely. And the real kicker here is you have to be aware of circumstances where you have these provisions. I've seen clients, unfortunately, that we've inherited. I've seen clients lose their businesses as a result of not having the right coverage in place for these kinds of claims. I've seen clients that have been socked with judgments, uninsured judgments, well into the seven figures on these kinds of losses. You have to be vigilant. And the other, it's good that we're bringing this up now, because really the other area, the hot button area of general liability insurance that you need to be cognizant of, or you really need to pay close attention to, is COVID. And what we're seeing in many instances, insurance companies are looking to add exclusions onto their policies for liability claims stemming from what's called communicable disease. And a communicable disease exclusion, for really for purposes of this discussion, it's a COVID exclusion. And what it basically says is we will not cover you for liability claims arising out of COVID. And the problem with that is, if you look at how construction contracts are now being drafted, in many, many instances, owners of projects, developers of projects, general contractors are looking to make certain that subcontractors are assuming risk of loss associated with COVID-19. And what that basically means is that you're using the right social distancing plans. They want to make sure that you're using the right personal protective equipment, or PPE. And to the extent there's any kind of clustering claim, and what that basically means is to the extent there's a mass breakout of COVID-19 at a construction project site, and those workers then look to file suit against the project owner for failing to maintain a safe project site, if they were to then in turn sue the general contractor, if that's who you are, or the subcontractor, if that's who you are, in the event you have that communicable disease exclusion, you will not have coverage for those lawsuits. So think about it this way. You are a subcontractor, ABC Construction Company. You work on a project site. Multiple employees of yours end up contracting COVID-19. They file suit against the construction project owner. They then look to you to pick up those claims. If you have a communicable disease exclusion on your insurance program, you will not have coverage for the owner's claims against you. So it is a very important kind of new brand or new age issue that everybody needs to be concerned about, not just action over.
So Josh, how are you navigating that? Is there certain companies that are not writing that yet? Is there an additional premium to avoid the inclusion of it? How's that working right now?
It's a good question. It's a challenging issue. Here's what I would say. I would say that we are not seeing, at least right now, an across-the-board position that COVID-19 exclusions are being added by all carriers. I would say the majority are adding it, but I would also say that there are a number of carriers that have not done that yet. So anybody that tells you that your policy is absolutely going to have a COVID-19 exclusion, I wouldn't necessarily believe that. I would tell you that you need to be very careful about the markets that you're choosing. By markets, I mean insurance companies. You want to make sure that you're with the right insurance company. To the extent that you need that COVID-19 coverage, try to seek it out. The other thing, obviously, that you would want to do outside of trying to make sure that your policy does have that insurance coverage is, of course, take a close look at your contracts. Talk to your construction attorneys. Talk to your insurance attorneys. If the project owner is looking to make you responsible for COVID-19 claims, do what you can to narrow that responsibility so you don't have to be presented with the claim in the first instance.
Very good. Thank you. I would also just add to all of that. One of the things that I see certain construction companies not doing is after they've determined what they need, not actually making sure they get what they need.
Absolutely.
Making sure they get the certificates of insurance from the subcontractors, making sure that the actual insurance program that they wanted to get was actually verified to be gotten and that they have the paperwork to prove it.
Such an important point. You always need to make sure that whatever you're supposed to get, you actually have. And the way that you do that is reviewing your policies carefully and your certificates of insurance.
Right. So you need to task somebody at your company who has the qualifications to make sure that you've gotten what it is you're supposed to get. A sort of compliance officer, for lack of a better word, because those types of mistakes are the mistakes that will put you out of business. So that's sort of a contractual liability exposure that you're protecting yourself from. What about some of the other exposures? Talk to me about and explain a little bit about completed operations.
Completed operations in a nutshell is you do work at a building. Let's say, you built out the drywall and you finish up your work at the job site. You walk away, the building is done. Everybody thinks that the drywall was installed perfectly and there are no issues. Fast forward, as can happen, fast forward a year and a half or 2 years, and all of a sudden the drywall collapses onto individuals living in the apartment or working in the commercial space that you built. And in that circumstance, they file suit against the owner of the building, claiming that the drywall was defectively installed. That is a completed operation in the sense that your work was absolutely finished. There's no corrective work that needs to be done to it at the time. You walk away from that building, and then after a period of time, a claim is asserted. Another really great example of completed operations would be, we'll use the example of a plumber. A plumber installs a piping system in a building, and then 2 or 3 years later, the pipes burst because a widget was defectively welded or whatever the case may be. Since you have walked away from that job is now complete. The damage that ensues from that defective pipe installation is now covered as a product's completed operations loss.
Okay. And do you see a lot of variations in the coverages for that, or is that just a standard part of a general liability policy for a contractor?
Products completed operations, you don't see much in terms of, variation from carrier to carrier. The one thing that you always need to be careful of, especially with products completed operations when you're in the construction space, is mold exclusions and other exclusions that are similar to that, fungus exclusions, microbial exclusions. Those kinds of exclusions, for the most part, are designed to bar coverage for ensuing claims related to water damage. So we see this constantly in, for example, the window installation space. If you're a window installer, you have a major products completed operations exposure because once you install that window, you're walking away from that job site. What can and very often does happen, if you have a defective window installation, over a period of months or years afterwards, water will slowly leak into that building and it will cause mold to germinate or to grow. And now all of a sudden, you've got a multi-million-dollar exposure on your hands. If you don't have the right products completed operations coverage, you may be out of luck.
Okay, so that's another exposure that you should be aware of in the general liability exposure world. What other aspects of a coverage for people in the construction industry do you think is critical for them to have in their preliminary portfolio of coverages?
So this is obviously a little bit, kind of business dependent or business specific, but too often we talked a lot about liability insurance because it really is, to me, a critical need for any construction company. Construction work is dangerous and there are a lot of liability claims. But contractors, in our experience, tend to forget that they should be insuring their own property as well, their own equipment, their own vehicles, their own materials. More often than not, when we inherit an account or a client, it'll be because their broker or their insurance advisor did not give them the right advice on insurance coverage for their own property. And if you're a construction company, you absolutely do have property that you're going to want to insure. If you're the project owner, of course, you're going to have what's called a builder's risk insurance policy, which you should think of as basically just a property insurance policy that covers the project while it's under construction. If you are a general contractor or a subcontractor, you're going to almost certainly want to have what's called floater coverage, which is going to cover your equipment, your materials on the job site. Those kinds of losses tend to end up being uncovered or without insurance because the contractor does not have the right property insurance in place to cover those risks or to cover those exposures. So when you think about your portfolio, yes, focus on liability insurance, but think about your builder's risk insurance, think about your floater insurance, and think about insurance for your office. We've had a number of circumstances where we've had construction clients that did not cover their computer equipment, their improvements and betterments, their furniture, everything that they had inside their business office space, because they just assumed that this was an exposure that you couldn't get picked up or you couldn't cover. Absolutely, you should be covering that insurance, that exposure, and there's a product available, and it's a relatively cheap product too, to pick up the exposures in office.
Great. So beyond that, besides obviously if you have vehicles, you're going to need coverage if they're on the road. And for workers, you're required in the state of New York to have workers' comp insurance. So those are going to be mandatory coverages for you to put a vehicle on the road or for to have employees. But does the thought or the analysis change, as I mentioned in the beginning, if you're now in the 5 boroughs of New York City versus just somewhere in New York State or elsewhere?
Yes. And the analysis changes somewhat because obviously, the 5 boroughs of the city of New York are what we call a high value venue or high value jurisdiction, in the sense that if you're looking to buy liability insurance, it is going to be more expensive if you're doing business in the 5 boroughs, simply because if there is a lawsuit or there is a claim and it's going to be filed, or the complaint or the lawsuit's going to be filed in the 5 boroughs, a jury evaluating those injuries in that jurisdiction is going to probably give you more money than if you're in another jurisdiction outside of the 5 boroughs, even within New York. It's simply just not worth as much money from a plaintiff's lawyer's perspective. So that drives up pricing. That's definitely the case. The other thing that you need to be on the lookout for is, and we talked about action over exclusions, your general liability insurance, if you operate in the 5 boroughs, it is essential that you make sure it does not have what's called a designated operations or designated locations exclusion, which bars coverage for any claim arising out of work in the 5 boroughs. I can't tell you how many times I've seen that. And it happens most often when you are headquartered in some place outside of New York City, but you do a lot of work in New York City. In those situations, the carrier will look to say, oh, I'll cover you for your work in New Jersey, but I'm not going to cover you for your work in New York City. So you definitely need to be on the lookout for that.
Okay. And what about all of the issues for, and this may not apply to construction, but it may when you're talking about improvements and you're dealing with questions concerning all of the various codes that change over time and that can impact your coverage or your ability to comply with laws that are being changed or modified or codes that continue to change during a construction project. Does that happen during the course, or is that really for something that's existing, is more for renovation projects?
Right. So it's an interesting question. If I understand what you're talking about, if you're talking about code upgrades or code enhancements, what's called ordinance or law coverage. So that's, in the course of construction, I'm less concerned about that. If I have a finished building and I'm moving it, and this is something we should talk about, so it's a good point you just raised. If I'm moving a risk or moving a property from a builder's risk insurance policy to a completed building policy, a commercial property policy, or even a residential policy, yes, you must have ordinance or law coverage. And what that basically does in its pure sense is, let's say I built a building in 1900 or 1912, right? And then it burns down as a result of a fire in part, and I'm going to rebuild that building. Well, the building codes that were in place when the building was originally built back in the 1900s are obviously not the same today. Codes change. And when they change and you have to repair a building, all of a sudden that building that was grandfathered in and didn't legally require those modifications, well, now they're going to need it. And a textbook example is handicap or disabled accessibility to buildings. In many instances, if there is a casualty event, if the building is damaged, and you're now going to be filing for permits to renovate or to rebuild or repair, the town or the city or the state or even the federal government may require you to add disabled access to bathrooms, elevators, etc. All of that is code upgrades, and that's where you would look to code upgrade insurance coverage in your property policy. I wouldn't call that a construction exposure per se. I would say that's more a question of, what a completed building is going to need in terms of insurance products.
Understood. Okay. One other question about construction is the world of surety bonds. Do you view that as just a whole separate topic? Because it's kind of not within the scope of the general coverages that somebody needs when they're doing construction projects, but ultimately they need to, for any decent sized job and a lot of jobs in the city, you're going to need those.
Right. So I would say that if anybody's going to be posting a bond on a project, typically, and listen, this all depends on project size, scoping, project value. Bonds absolutely can and will be posted. Typically, the general contractor is going to post a bond for its work. There are products, relatively newer products that are out there, such as SDI, which is subcontractor default insurance. It's sometimes used for subcontractor work where the expense for the cost of the bond is offset through a program that the general contractor brings to the project site. But for the most part, I would say bonding is something that's typically handled by the general contractor and or required by the owner. Again, it depends on project size. Larger, far more complex projects, you will definitely see a bond place. Smaller jobs, less so.
Okay. Is that something that you and Sterling handle?
Yeah, we regularly do it. The bond market is actually a specialty market. We work with our strategic partners who have access to the specialty markets that write or that underwrite bonds. But we do that as part of our core business. Yes, absolutely.
Excellent. Well, this has been very, very, very informative, as always, Josh, and I appreciate your time today. And I appreciate all of the listeners who tune in and check out what we have to tell you about. So I want to close by saying thank you for listening today. And if you like the podcast, make sure you leave a review and subscribe so you don't miss an episode. You can visit the Schwartz, Conroy, and Hack PC website at www.schlawpc.com for more information. I'm the insurance lawyer. Have a fantastic day.